Hello, those that are joining us. This is Rick Durfee. We're going to start our presentation now. I think others are trickling in as we go. My name is Rick Durfee with Durfee Law Group. We're excited to have today's presentation on what financial advisors need to know about planning for 1,000 years. I know that might sound a little pretentious, but the fact is a lot of estate planning is single use, it's singular, it's death focused. What happens when somebody dies, and then we throw it away and we're done. And if we're going to create significant wealth or even modest wealth, and if we want it to last and be beneficial to our descendants, that requires some long-term thinking and some long-term planning. And that kind of long-term results does not happen by accident. It happens on purpose. We have to be deliberate about it. And that's also something that requires a team. So we call that integrated planning when we have a team of advisors, a team of lawyers, a team of people involved in putting together the plan. And so I want to tell you who's going to be presenting today. Myself, I'm Rick Durfee. We're going to have Michael Koberlein and Sam Kelsall and Kyle Hopson, who are also attorneys with the firm, each presenting a piece of today's presentation. And part of the reason for that is to demonstrate, I guess, by example, that we have a succession plan. We plan for the firm to be here for 1,000 years and serving our clients and their descendants for a long time. And so the concept of legacy planning or dynasty planning is something that is not necessarily new. In fact, kind of an interesting story. Some time ago, I was in Egypt, and our guide was pointing to this big stone rock, and he said, this describes an arrangement where this individual was given all this property from here, this vast area of property, to his descendants in perpetuity forever. And it was 5,000 years old, and those people were obviously long gone. But the point is they were planning on it, and we still have the record of what they attempted to do. So realistically, we recognize that in 1,000 years, the world is going to be a different place. But if we have a plan and if we are moving towards a positive goal, that has a greater probability of producing an output that we want than if it doesn't. So the concept of dynasty planning is multi-generational. We're looking down the road. We're anticipating the kinds of things that may come up. We're putting tools in place that we may not use in our lifetime, but that others may use as they come along behind us. And there's a couple of things I want to mention in particular that drive this kind of planning. One is there's an archaic rule that we borrowed from England called the rule against perpetuities that basically required entities or structures to have a termination date, an expiration date. They had to end by that date. And that rule has, to a significant extent, been thrown out or modified or adopted, both domestically in the US and for sure internationally. And although some states still have some vestige of a rule against perpetuity, the majority now do not, or at least have extended it long enough that we'll all be dead by the time something happens with it. So we had this rule against perpetuities that is gone, which allows us to create structures that are intended to last theoretically forever, and at least don't have any expiration date that's built in and automatic. They may still retire, they may still come to an end, but it's not going to be something it's not planned obsolescence. It's not deliberate obsolescence. We're going to be deliberate in looking to the future. Another kind of poorly understood, often poorly implemented or not implemented at all feature of the law are these exemptions from transfer taxes. And there's one in particular I want to just give mention to here in the beginning of the presentation called the generation skip tax exclusion. When assets transfer from one generation to the next, there's a tax on that. If that transfer is going to go more than one generation, so if it's going to skip a generation, there's a tax on that. But there's also an exclusion on that tax. And taking advantage of that exclusion combined with perpetuity planning allows us to build wealth that, at least under the current structure that we have today, that can transfer over multiple generations and avoid several layers of tax, which is really powerful and allows for multi-generational compounding of wealth. So people who, for example, did this kind of dynasty planning 100 years ago and successfully avoided this tax may have started with less than $1 million, but today have hundreds of millions and in some instances, billions of dollars. So looking forward down the path, our clients might say, well, I don't have gobs of wealth. My wealth isn't that significant. Do I really want or need this? And well, maybe, maybe not. Are your heirs or your descendants going to consume your wealth and eat it up? Or are they going to build it and grow it? And do you want to put tools in place to maximize the probability that they'll build and grow it? Or do you want to just let them have at it? Which ties into another introductory thing here before we dive into this. Inherited wealth is a catalyst. It triggers a reaction. And that reaction can either be very, very positive, very powerful and good, or it can be very negative and destructive. And how we transfer the wealth, what we do it with, the conditions and structures with which we leave wealth will make a big difference on what the wealth does to our descendants. And families that have certain structures in place, that have certain cultures, that have certain ideas that are dominant in their family and given life in the estate planning structures, will have a healthy relationship with wealth, and they'll grow it and build it, and it'll be a good thing, and it'll produce powerful and productive and effective individuals, people that we want as neighbors and friends and leaders in our community. And people that don't have a plan are at much greater risk of having the wealth be destructive and negative. So with those things in mind, I'm now going to turn the time over, and I'm going to tell you that Michael Koberlein is going to speak, and then Sam Kelsall, who, by the way, he has the distinction of being the longest practicing attorney in our firm. We're excited to have him as part of our team. And then Kyle Hopson is going to speak, and then I'll wrap up at the end. So at this point, Michael, if you will unmute yourself, we're going to let you take it away.
All right. Thanks, Rick. And glad that everyone's here with us this morning. Welcome to this presentation. One of the things I'd invite you to do, if you have questions during the presentation, you can put those in the chat box and we'll try and answer those as we go along. I'm going to talk about a few different basic items and then some more advanced things, but the primary thing I'm going to talk about initially is basic documents, and then I'm going to go into revocable trusts and irrevocable trusts. Basic documents are going to be made up of 4 documents: your last will and testament, durable general power of attorney, medical power of attorney, and living will. The last will and testament traditionally is going to be a document where you can transfer your assets at death or distribute them at death, and then also name guardians. For example, if you're a parent and you want to name guardians for your minor children when you pass on or become incapacitated, that's where you would do that. Your medical or your durable general power of attorney is going to be where you name a decision maker who will be making decisions on your behalf in the event they become incapacitated. And those decisions will primarily be financial decisions. The medical power of attorney and the living will, those are kind of tandem documents. They're both medical documents that allow you to choose a decision maker, and that decision maker can make medical decisions on your behalf in the event that you become incapacitated. One of the primary differences between those 2 documents is that a medical power of attorney is going to be for those temporary situations where you're going to go into the hospital and have a minor or maybe a major surgery, but you know that you're going to come out and you're going to be okay. But during that time, if you become incapacitated, then the person who's named as the agent in your medical power of attorney is going to be the one who makes decisions on your behalf. The living will is also a medical document, but it's for end of life care. So if you are going into the hospital or into hospice and you know you're not going to be coming out, then the decision maker that you've appointed in your living will is going to be the one who makes end of life care decisions on your behalf. Those are the basic documents. And just as an aside, for your clients, if your clients are 18 years of age or older, these are documents that they should have. When they become adults, these are documents that any person should have, so that they have these things in place to be able to allow them to really have some security in emergency type situations and allow for their loved ones to be able to provide for their care. Now we're going to move into a revocable trust. For the most part, most attorneys who provide a revocable trust are trying to do two things. They're trying to help their clients to avoid probate, and they're also going to try and help their clients to distribute assets through the trust. And typically that would be to children upon a certain age. So they'll make mandatory distribution provisions in the trust that say, junior gets asset A at age 18, asset B at age 25, and asset C at age 35. That is fairly common, but we're going to talk about why that's something that we should guard against when we're planning, because of some of the things that could happen as a result of that type of planning. And what we do as a firm to help people to plan, as we've talked about for 1,000 years. So a revocable trust is a contract that controls property over time. There's three parties. You have the grantor, who's the creator of the trust, the trustee, who manages the assets and controls the assets of the trust, and the beneficiaries, who enjoy the assets in the trust. We do believe that planning to avoid probate is very important. We also believe that provisions in the trust that allow for protection of the assets for beneficiaries are important. And you'll see often in most trusts that there's a spendthrift clause. And a spendthrift clause essentially says that the trustee has the power to protect the assets in the trust from creditors. What most people don't know is that if you put mandatory distribution provisions into the trust, that the spendthrift clause can be clobbered by those mandatory distribution provisions. An example of that would be if you give the trustee the power to protect assets from creditors, but then in the same trust, you bind the hands of the trustee to distribute assets to junior at age 18, and junior is going through some kind of a lawsuit or a business issue. That's pretty young to be doing at age 18, but let's say 25 or 35, they're going through this. It doesn't really matter what age, but if it's a mandatory distribution, then the trustee is not able to hold back those assets while the beneficiary is going through a bankruptcy or a divorce or a lawsuit or some kind of business issue. And as a result of that asset becomes a part of that beneficiary's estate while they're in that difficult situation in life. That's what the mandatory distribution does. However, if we allow the trustee to exercise that power that the spendthrift clause provides by not putting in mandatory distributions into the trust, but instead allowing the trustee to have absolute discretion on distributions, then we provide the trustee with the power to protect the assets of the beneficiaries, and so that a trustee can withhold those assets and not distribute them if the beneficiary is going through a divorce or a lawsuit or one of those things mentioned prior. And so in that way, we allow the spendthrift clause to have some meaning. The other thing that Rick touched on briefly was Dynasty Trust, and we specialize in drafting Dynasty Trust at the Durfee Law Group. Part of what we want to do is help people if they want to allow their trust to go on in perpetuity. And if we draft the trust in such a way that we allow for that, then our clients can use that trust for generations. One of the other things that you might see as an advisor with a lot of clients is they'll have a trust that's just a single use type trust. We're gonna, in those trusts, they'll distribute everything in one lump sum or one distribution, and then the trust doesn't have a use anymore. We think that having a trust like that is fine in limited situations, but in most situations, people want to be able to allow for their wealth and their legacy to go on for generations. And so that's the type of planning that we want to provide. One of the ways that we protect our clients is oftentimes you'll hear things in the news or maybe you have friends that have gone through some pretty hairy litigation as a result of one of their family members having a loved one who's passed away, and their estate goes into probate. And their estate goes into probate, and it invites people from everywhere to come in and fight about what that person had. And if there's a lot of money in the estate, then it becomes a huge issue. Unfortunately, that's something that can result in the estate being dwindled. And to guard against that, we have in our documents what we call an integrity agreement. And the integrity agreement, one, we want to make sure that people's family relationships are protected, and that they're able to thrive as a family, even if they have somebody that is close to them pass away, and even if there's a lot of money that all of a sudden becomes accessible to the family. And so the integrity agreement, what it does, one thing that it does is it tells those beneficiaries, anybody who brings a lawsuit is going to be disinherited. And so it's a pretty big hammer for people who want something and are trying to fight about it, when they realize that they can't fight about it, and if they do, they're out. Then it's a disincentive to litigate. But we also recognize that it's important for family members to have some sort of method in which they can resolve issues or real concerns that come up. And so as part of the integrity agreement, we have a anti-dispute resolution, which allows for 4 stages of dispute resolution outside of court. And in doing that, it's our hope that family relationships can be preserved and that people can resolve issues amicably. One of the things that we also recognize in our trust is that we live in a global economy. We live in a world today where people move around a lot. Their children aren't always living in the same place that they did growing up. And so there's a lot of people who are in a lot of different places in our society today. And so we draft our trusts independent of jurisdiction, so that if you have a trust that's created in Arizona and you're going to move to Florida, that you can take your trust and you can take your family And it's not going to be a situation where you have to redo everything in order for your trust to be to work in Florida. It's a way for us to just help our clients out and recognize that people have a lot of change in scenery in their lives. I want to move to irrevocable dynasty trusts briefly before my time is up here, and talk about the main difference with an irrevocable trust. So revocable trusts are going to be include all those things that I talked about. An irrevocable trust is also going to include all those things that I mentioned, you know, the spendthrift and discretionary distributions and your integrity agreement and other things. But it also allows for asset protection and tax planning. The tax planning part of that is your revocable trust. Anything that your revocable trust owns is going to be inside of your taxable estate and subject to the federal estate tax exemption. However, if you have assets that are in an irrevocable trust, then that's going to be outside of your taxable estate, and it's not going to be counted or included in your federal estate tax exemption or for federal estate tax exemption purposes. And so one of the benefits of that is when you transfer assets to an irrevocable trust, although you technically lose ownership, you maintain control, and those assets are outside of your taxable estate. And so with careful tax planning, assets that some assets may be included in your irrevocable trust and benefit you on a tax in tax planning. And then also for asset protection purposes, any assets that you transfer into the irrevocable trust because you don't technically own them are not going to be subject to your creditors. One of the things that I would encourage is if you have clients that have documents that they haven't had reviewed for a while, those things should be reviewed periodically and also updated periodically, just because laws change, things change, and circumstances change. So if you do have clients that you can think of that are in that situation, we review trusts for free. We do consultations for free, and we want to help where we can. So those are the things that I had to share. Rick, do you have anything before I?
No, I really appreciate that, Michael, and thank you for your perspective on that. And one of the things I love about having other attorneys in the firm speak is they say things I wouldn't say and bring a fresh perspective. So that's really awesome. Thank you, Michael. We're going to now hear from Sam, who is going to. Oh, there we go. Awesome. Okay, Sam's up, and again, we're happy to have all of our attorneys with us today, and Sam has the distinction of having the most miles on his tread here. So, Sam, take it away.
Okay, what I want to talk to you about today is the initial contact with clients. All of these plans are not going to work if you're not getting good information from your clients. So I'm going to review some of the places where we see problems in getting information. Number one, lots of clients will not tell you the names and contact information of all their kids. Those are the ones they want to disinherit. You need to know that as a planner, and we need to know that as an attorney. They forget about fractional interests in oil wells in Oklahoma and Texas. I've had a case where one of those turned into $1 million for my client and his sister. So that's an important planning thing. Even though they appear to be almost worthless, they should be carried on. They forget about a trust that they did before. I've had that over and over where they've made a trust 15 years ago. They put their house into it. They haven't done anything else. They pay the real estate taxes and never notice that they've got a trust, and all of a sudden we're checking their real estate and see it's owned by a trust, and all of a sudden we've got to change course and talk to them about what we're going to do with this other trust. They forget that they inherited those oil and gas interests in Oklahoma or Texas. One of the things that they're really not open about is when they're supporting kids that are over 35 that live at home. If that's something you as a planner need to know, and I certainly need to know it as an attorney. They look at you as only needing information about the assets that they have you managing, not the whole picture. And you can't give sound financial advice if you don't see the whole picture. So I'm going to tell you a couple of little stories about what has happened with me and other planners about assets that are under management. I had an occasion where a prudential agent contacted me and said, hey, I'd like to refer you about 135 clients a month. I said, what do you mean? He said, well, there's 135 people that move into Sun City every month, and I call each one of them and welcome them as their prudential agent. And then I said, wait a minute, how do you know that they have a product with Prudential? He says, well, 95% of people do, so it's pretty good odds. And I tell them I'm really not there to sell them anything. I've set up a free appointment for them with an attorney. So for a long period of time, one day a week, I went to his office and met with these people, and they disclosed their documents to me as well as their assets so that both of us could work on their estate. That was a very satisfactory type thing. Okay. Another example of an advisor that I worked with was Gene Letson, who had only school teachers for clients. Now, before I met Gene, I had never met a school teacher that had a worthwhile estate or had any worthwhile investments, because they tend to invest in screwball things with the first guy that comes along. Well, Gene was lucky enough to be in a position when they first got their job to talk to them and explain to them that they needed to be saving 10% and they needed to put their raises into their savings. So by the time I came along, he had 800 clients that had $1 million a piece or more in investments, and that in many cases didn't count their real estate. So he set up seminars every week for about 2 years for 10 couples at a time. And I'd give the estate planning seminar, and then he would say, okay, before I see you the next time, you need to see Sam and get this estate plan taken care of, because it's going to affect what happens with the rest of your life. So if you can't get the things done at the beginning, you can't get them done. Now, the third advisor I want to talk about, I ran into a couple out of the West Valley that were from Omaha, Nebraska. Their financial planner came down every year and saw 200 clients during the winter, but he didn't know anything about community property. And they came here with 2 trusts from Nebraska, as most of the people do. And I said, hey, we can't have that. We've got to have a community property trust in Arizona. Well, they went and talked to their planner about it. He was quite skeptical. And he came to see me and we talked about it. And I explained to him how by claiming their residency in Arizona, which was true, that they could have a step up in basis on all of their property when the first one died, and again when the second one died. He was so amazed by that the next winter he referred all 200 of his people to me to do community property trusts. So those are how you as a financial planner can work with a lawyer to get good information that then makes for good estate planning, especially along the lines that Rick's been talking about.
Thank you, Sam. Take it away, Kyle.
Will do, unless you had anything to add beforehand, Rick.
You're great. Appreciate
All right.
both of you.
No worries. So as you heard, I'm Kyle Hopson. I'm a probate attorney here at the Durfee Law Group. I'm going to briefly be covering estate administration and probate as it relates to planning. And the initial portion of this, I just want to talk a little bit about doing it yourself versus getting professional help. As we know, there's a very big difference between the two. Estates and planning, it's no different. We all know people that say, well, this doesn't seem too hard or this doesn't look that difficult. But the reality of it is that financial advisors are pivotal when it comes to planning, especially for the future. But there should be an integrative approach, and I'll touch on that some more as we get on with this. But when it comes to estate administration, there's this idea that when someone dies, you're going to have a bunch of people get together next to a fireplace. You're going to have the attorney standing there, and he's going to read a will to everybody. And at some point, somebody's going to be shocked that they inherit everything. It just doesn't work that way. There is no requirement for that. The people that are going to receive notice when it comes to estate administration are going to be the people listed in the trust or in the will. And essentially, generally, a lot of times when that's done, it's just done through a letter. So there is no kumbaya moment in front of the fireplace. It's a lot more simpler than that. When it comes to administering the estate, again, you want to use an integrated plan. Sam touched on the community property. Again, you do get a step up in basis for community property. That's something that planners are going to want to know. That's something that you want to touch base with attorneys on so that that can be incorporated into the plan. Another thing that Mike touched on was irrevocable trust. And essentially, when you have an irrevocable trust, generally you have a trust where somebody has now passed on and the trust cannot be amended or changed. What's important to know about those as well too is that irrevocable trusts require you to get a separate EIN. They also can require you as well as to do tax reporting. For most estates, this is going to be just income tax. For the larger estates, this can also include estate taxes. Financial advisors can assist using the integrative approach. This can provide your clients not only with better protection, but it gives them a better service as well. The next portion of this that I'm going to touch briefly on is going to be on the probate aspect. And so this is essentially what happens to somebody when they don't do the proper planning, when they don't have these documents in place or just any plan in place. So for people that don't have much in terms of they don't own a house or don't have very much personal property, the families are generally left to deal with this. This is something that's generally going to take place outside of the courtroom. These are also generally not going to be the individuals that are seeking out financial advisors to get help with their estates. Now, for everybody else, if you haven't planned properly, you're going to end up in probate. And this essentially means that you're going to be having the court deal with everything. Now, there's a common misconception that, well, if I have a will in place and the will, references things, I'm good to go. There's no issues there. I can avoid probate. The reality of it is that a will almost always will guarantee that you're going to have probate. In order to prove a will, you have to send it through the court. It's a good idea to have a will. And as a matter of fact, as Mike mentioned, it's something that you want to have. It's some of the basic docs that everybody wants to have in place. But the reality of it is that the will should be a backup plan for people that have more assets than that. If we're talking about a couple things here and there, that's fine. But when you're doing full-blown financial planning, the will should be a backup plan that covers things that seem to fall through the cracks. Now, in terms of probate, how much does probate cost and what are you looking at? I mean, what's the downfall of not planning? And the reality of it is that probate can cost, a couple $1,000s for somebody that has maybe a house, a car, maybe even a couple accounts. But for larger estates or even smaller estates where there's some kind of argument or contest, They can range from several $1,000s to tens of thousands of dollars. And if you're talking about these extremely large estates, the amount only goes up from there. The same thing too, when a cost of probate, you're also going to be looking at several years. A very small estates will on average take about a year to wrap up, usually a year or two for the smaller estates. If you're talking about very large estates, those can take years. One famous example of a very long probate that's been going on deals with Anna Nicole Smith. Her probate has actually been going on for a couple decades. Last count that I saw was up to 22 or 23 years. And the judge in that case actually recused himself because he got tired of dealing with it. One other aspect of this too is, well, if you have probate because you didn't do what you're supposed to, how can you avoid probate? And the simple solution to that is essentially putting all this in place, having a decent plan in place that addresses all these. Trusts are a good option. Trust, if they're properly drafted and properly funded, can avoid probate entirely. The problem with that, though, is they have to be properly drafted and properly funded. And so you're going to need to have help with that. You're going to need to have an attorney that knows what they're doing with that. I know our firm sees that quite a bit with trusts that are missing things and need to be corrected. But it's one of those things that if you intend to provide clients with the best service, you're going to want to have integrated planning. You're going to want to use attorneys. You're going to want to use accountants. You're going to want to make sure that you cover your bases so that not only are they set up for their lifetime and even their kids' lifetime, but you want to set them up so that they can actually last for that 1,000 years, as everybody's been talking about. And so essentially just make sure that you use that integrated planning. That's the gist to avoid all this and all the cost and headaches that come with it. I think that's about it for mine. So Rick, if you want to take it back over.
Awesome. Thank you all. And I really appreciate all those that have helped with today's presentation, and that I want to emphasize the fact that this kind of planning for 1,000 years is a team effort. It's something that takes more than one person. It requires the attorney, it requires the financial advisor, it requires good tax advice, insurance advisors, and that integration of the team working together collaboratively for the benefit of the client is essential. And this kind of planning, this planning for 1,000 years, applies to all levels of estate, both the small, simple ones and the big mega estates with enormous amounts of wealth. All of them can benefit from this. I've had people ask me, well, at what level for example, do you implement some of the tools I'm about to talk about here, the family office and the family bank? And for sure with the very large estates, but we've had clients come in and they have what might be a modest amount of money, a few $100,000, but they're in a profession or they have a business where that might be at risk, or a family situation where that might be at risk. So even though the amount is modest, the risk is high. And so they would benefit by a more complex or a higher level of planning than maybe somebody with a similar net worth. So we're going to talk here for a few minutes. I'm going to mention three structures. We've heard about the Dynasty Trust. We're going to talk about the family office, the family bank, and the family foundation. And I'm going to show a screen here. So this diagram here shows the two trusts that Michael talked about, the Revocable Trust, which is the blue one up at the upper left-hand corner, and the Irrevocable Trust, which is the green one. It's below the generation line outside the taxable estate. I want to hit on this family office idea. And family offices have been out there. Anybody with significant net worth, they've heard about it, they've been pitched. You should have a family office. And we hear people all the time that will come and say, I have a family office. And I'll ask them, well, what does that mean to you? And what it often means is somebody sold them a bundle of services. We're going to bring in a financial advisor and a CPA and a lawyer, and we're going to render these services for you as a package. And that's your family office. And just saying, in my view, that's not a family office. That's you purchasing a bundle of services. If you really have a family office, you own it. And there will be a legal structure that houses or facilitates or empowers that family office structure. And that legal structure will be integrated into your estate plan. Now, it still may engage all those service providers we talked about, somebody to help manage the money, somebody to do the taxes, and somebody to keep your property and legal stuff straight, and somebody, your CFO and your COO and all those kinds of things. But that's going to happen under your business entity that you own, so that you're not just vulnerable to or subject to whatever services somebody else happens to provide. It's your deal. And so we typically structure that. That's this purple box that you see up here. We will typically structure that as an LLC taxed as a corporation. And it could be a C Corp, it could be an S Corp, depending on how it's structured. But you will note, I want to, when you see these diagrams, by the way, we prepare diagrams like this for all of our clients. So the client, their advisors, the team can see what are the structures, how do they fit together? And you as the advisor, if you don't understand what's going on with the structure, you can't help the client, and you're going to step on something that hurts. Either you or the client. So understanding what these structures are and how they fit together is crucial. The family office will typically be owned, a very small amount will be owned by the Revocable Trust, and the lion's share will be owned outside the taxable estate by the Irrevocable Dynasty Trust. And there's some variations on that depending on the circumstances. But among other things, that means that family office is an heirloom asset. It's something that we're going to keep for a long, long, long time. And we're going to have generations of things going on with that family office and that affect and help the family. One of the things we do in the family office is that's where we put control. So the family employees, all the C-level officers, business vehicles, and we put liabilities and expenses in the family office, but we put no assets of any significant worth. The family office itself doesn't own the assets. So if you have investment accounts, we have investment advisors that will come to us and will say, I put all their brokerage accounts in the family office. No, don't do that. Please don't do that. That's where the liability and the risk is. We don't want the assets of value there. We want to segregate those out. What we do want in the family office is control. So that's where we're going to engage the lawyer and the CPA and the financial advisors. That's where we're going to have family members that may be employees or outside members, outside non-family members that are employees to serve the family. And we're going to run the business there. That could be a business incubator where what the family members say, I have no idea, let's try this. And they can try it. And once there's proof of concept, then we can move it into its own entity. But that family office, control, no equity. Then the family bank we show a single entity here. The reality is over time, especially as an estate grows, where the money is, there's going to be more than one place. But we want to have some centralized control. We want to have a clearinghouse where funds can move in and out of in a tax efficient manner, and so that they're protected from risk events in the family. We're showing here a limited partnership. It is a business limited partnership, which is to be distinguished from what used to be called a family limited partnership. Although this is owned within the family, it has a business purpose. It has non-tax business purposes, which are crucial for it to get the attributes that we want, including the tax attributes and the asset protection attributes. So why do we care? Well, this, by the way, if you're the financial advisor, it's under this family bank structure somewhere that you're going to put all of the non-qualified investment accounts. This is where the brokerage account's going to go. This is when the client says, well, I have extra money. Where do I put it? You put it in the family bank. So if we're starting out and they're fresh and they have nothing and they've owned all their brokerage accounts personally, for example, and we're creating these structures, one of the crucial things that has to happen is we need to move those brokerage accounts out of your personal name into the family bank. And this is an example of one of the reasons why this is a team effort. There are tax reporting consequences from that. And so the lawyer has to be involved, the CPA has to be involved, the financial advisor has to be involved, and we have to each know what the other one's doing. So we have to share notes, collaborate a little bit here, and communicate. And something along that line I want to mention is, how do we do this as a team with a group of advisors? It's really crucial that there's an open door policy among the advisory team that they can call each other, because it's often the case that one of the members of the team will be the first one to spot a problem or an issue, And they need to be able to pick up the phone and call the other members of the team and say, hey, here's an issue I just saw, and we need to take care of it. So if it's, and often it's whichever one of the advisors has the closest and most intimate relationship with the client. And candidly, that is rarely the lawyer. People don't want to call their lawyer. They're afraid of calling their lawyer. That lawyer's going to bill me. So who are they going to call? The guy that's free, or that they at least feels like it's free. So it's going to be usually the financial advisor or the CPA. So they're going to call and say, hey, I bought a new one of these. I bought a new rental property. I bought a new tractor. I bought a new business. I bought something, my daughter and we're doing this deal together. Well, that often requires input from the balance of the team. The other members of the team need to give input so that that's structured properly and doesn't hurt, doesn't create unwanted risk or have unintended consequences. So within this family bank, I want to mention some of the attributes of a limited partnership in general. And this same idea applies with some variation to LLCs, but the model that works well for this particular application is a limited partnership. By law, limited partnerships have two kinds of partners. They have limited partners and general partners. General partners have control. Limited partners have no control. General partners have general liability. Limited partners have no liability. So who do we make the general partner? Well, where are we putting control and liability? We're putting that in the family office. So that family office entity is going to be that 1% general partner. You can see that on the diagram if you're still looking at this. See that little 1% general partnership, follow the purple line, comes over here. It's the 1% general partnership owned by the management company or the family office. So what does that mean? Control goes there. What does it also mean? Any liability that spills out of that family bank is going to come to the family office. And where we have how many assets? Virtually none. Cars, we have liabilities and things like that in this family office, but we don't put the cash or the portfolio investments or the rental properties in there because we don't want those valuable assets to be vulnerable to potential liabilities. So, but we have control there, which is awesome. So the family can run the business of the family business through the family office. In that business limited partnership, then you'll see here, it's going to have an operating account, it's cash and portfolio investments, rental properties, and we can do some other creative things to protect assets in the family, equity strips on real estate and residential properties, loans to family members and other things like that. This family bank will also often own some number of subsidiary entities. So if we have a rental property, for example, a commercial building, or even some ancillary business, we'll often wrap that in a subsidiary LLC that will be owned partly by the family office or family bank, excuse me, and partly by other things. But you'll notice here on this subsidiary, who's the entity? The manager is the management LLC, which is the family office. But does the family office own any of that? Nope, owns none of it. The limited partners of this limited partnership are, the blue line comes over here to the blue trust, the revocable trust, and the green line goes down to the irrevocable trust. And how much is owned by which? Well, the blue line going to the revocable trust is the ungifted portion of that limited partnership. The green line that goes down to the irrevocable Dynasty Trust is the gifted portion. When we put stuff in that green trust, depending on how it gets there, but if we have it today and tomorrow it's in that irrevocable trust, it got there by way of gift. So there's some coordinating to do there. And here's something that we encounter frequently. People that need to make these gifts for tax purposes are afraid to do so because they feel like, well, when I make the gift, I'm giving up something. I'm writing a check to my children and they get the money now and I don't get it. And with this structure, it's important to know, no, they don't get the money. They don't get the money. Where does the money reside? The money resides in the family bank. It doesn't leave the family bank. It doesn't come out of the family bank and go into the Dynasty Trust. It doesn't come out of the family bank and go to the children. The portfolio assets, the money resides in the family bank. Who controls the family bank? Well, the management company, the family office controls the family bank. Who controls the family office? Mommy and daddy do, so they have control. What have we, when we gift a fractional share of this business limited partnership to the Dynasty Trust. What have we given? We've given them a limited partnership interest. So they have equity. So if someday over the rainbow, if this is ever sold, they get that equity through the trust. But how much do they get today? They don't get anything. But the assets are outside the taxable estate, unavailable to creditors and all those good things. But mommy and daddy are still able to make the investment decisions, buy and sell properties, and provide for the needs of the family, including their own needs. That's the family bank, and some tremendous uses with that. And I want to mention something that's not on my diagram, actually, but I want to mention it for purposes of this. When you're consulting with the client and they say, I've got this genius idea, and we're going to make a gajillion dollars with this idea. How do we structure that? We call that a new deal entity. We want to structure that so that it's outside the taxable estate. And this, by the way, is one of the mechanisms that ultra high net worth families use to create new wealth that does not get taxed when somebody dies. We structure that new wealth so that it is owned mostly by the Irrevocable Dynasty Trust, partly by the family bank, and controlled by what? The family office. So mommy and daddy have control of it, but the equity is mostly outside the taxable estate. This is how some families, some of whose name starts with W, you can figure out who they are able to create billions and billions of dollars. And when grandpa dies in a year when there's only $600,000 of exclusion from federal estate taxes, manages to pass his estate to 5 different family groups and create the 5 richest people in the world and pay $0 in estate taxes. This is a powerful move. And if you're representing clients that have significant wealth and you're not taking advantage of these moves or helping them do it or helping them understand it, you're hurting them. And by the way, they're going to give a big chunk of money to the IRS. I've never found anybody that's really happy about that. Even people who say, oh, we should raise taxes, they're usually talking about raising taxes on somebody else, not on them. The last structure I want to mention here that's super critical is something called the Family Foundation. And I want to point out that for the planner, the Family Foundation can take a variety of forms. In the beginning, in the early years, it can be a donor advised fund. It may be a private foundation. It may be a private operating charity. It may be what's called a support organization. It may be a fiscal sponsorship, which is an emerging new kind of charitable structure. And what is best for a particular family depends on their situation. And who should provide that donor advice fund? There are lots of providers, and they all have a different deal. One of the things we want to look at, if we're truly planning for 1,000 years, is does the donor advised fund provider allow future generations to have advisory rights? Some do, many do not. So often, if you're establishing a donor advised fund with an organization that says, yeah, we'll let mom and dad have advisory rights, but when mom and dad are dead, it's done, it's over with, the funds now come to our general fund. That happens a lot. Or even some organizations will say, yeah, we'll allow we'll allow the children, but not the grandchildren. So that's a question to ask. There's some reasons why we recommend and prefer certain donor advised fund providers, and we can talk about that, partly because they will allow for dynasty planning. They'll allow the family to have those advisory rights over multiple generations. They will also allow the advisor to manage the funds in that family foundation, regardless of the platform the advisor's on. So if the advisor, for practical or licensing reasons, decides, well, I was on platform X and I'm going to platform Y, they can take that fund with them, and they don't have to leave it behind because they, for professional or business reasons, decided to change platforms. So we want some independence with that family foundation provider, and we want some confidence that the family can continue to enjoy the benefits of that charitable planning over multiple generations. So why the heck do we do charitable planning? Here, and I want to first talk about what I call the accidental or the reluctant philanthropist. often we have an ugly choice. Sometimes by virtue of how things are structured in the tax law, we have something that we think is ours. We act like it's ours, but it's really not ours. We have temporary custody and it's going to leave our custody. And the only thing we can choose is where it goes when it leaves our custody. And the default is often custody will transfer to the taxing authority. The taxman is going to come get it. The IRS is going to take it. Or we can divert those assets away from the taxman to some charitable endeavor. And if we're going to have it go to any charity, why not have it go to our charity where we have ongoing advisory rights and can pick and choose what kind of charitable causes receive the ultimate benefits from that foundation. So when we have assets that are going to be taken away from us anyway, wow, let's capture those dollars. Let's have them in the family. That becomes social capital that the family can then use to promote and encourage charitable giving in their own community. So there's that tax issue, a part of the charitable planning, but there's another crucial factor that I want to point out. And this is something, this ties into the big picture here. If we're planning for 1,000 years, what matters most is not the money, it's the people. And if we mess up the people, it doesn't matter how clever we are at building and growing the money, the people won't be there to enjoy it or benefit from it. So we have to protect the people. And here's the reality that we observe over and over again. Families that have long-term, multi-generational, healthy relationships with wealth give to charity. They have a culture in their family of charitable giving. And it doesn't have to be the same. This one might give to a church and that one might give to some other political or social organization that they believe. So it can be very, very different based upon that family's values and cultures, but they have a family culture of giving. And there's something about creating wealth for the purpose of making the world a better place and helping other people that makes us more effective at it, that changes our decision-making process. What am I going to do with this money? Am I going to live riotously and self-indulgently and engage in self-destructive behavior because it tastes good and it's kind of fun? Or am I going to use this wealth that I've been blessed with to make my world a better place? And that culture, that tool of charitable giving just has a huge impact on the family. So in a 1,000-year plan, are we going to have all of these? Not always. Sometimes we'll only have one of these various tools that we've talked about. But often the larger the estate is, the more long-term thinking the family has, the more of these tools that we'll integrate, that we'll implement. And whatever number of, if we have 3 of the 4 or 2 of the 4, once again, it comes back to this is a team sport. We can't do it alone. The law firm, we can do legal documents, but the legal documents are pointless if the financial advisors don't help us get those entities properly funded, if they're not managed appropriately. So kind of to recap here, in planning for 1,000 years, there are some specific laws that we can take advantage of. There are some specific structures that we can put in place. We can coach and counsel family members so that they're thinking beyond what happens when grandpa dies. They're thinking, well, then what? How is this going to impact our family? And what are we doing to preserve that legacy and build a dynasty that will last for a long, long time? One of the things I want to mention that has been said already, but to emphasize, we have relationships with advisors, and one of the things we provide to advisors is you can call us. If you have a question, we're concerned about this or that, we'll talk to you. And to be fair, sometimes it works best if you schedule a time, because if we're on the phone, we'll take your, if we're available and you call on the phone, we'll take your call, but sometimes we're not available, so it's more convenient if we schedule a time. We'll answer your emails. We will review clients' documents on a complimentary basis, and everybody gets at least one free meeting. And often in that free meeting, we can figure out if it makes sense for us to work together. And in fairness, when we review trust, for example, sometimes, in fact, I just had this happen this last week. I looked at a trust and I said, well, wow, this is a pretty decent trust. It does these 7 things really, really well. It does not do these 3 things. Do you care about the 3 things it doesn't do? And the family said, yeah, we don't really care about those. Then my answer was, hey, you're done. You're golden. I cannot improve upon this if you don't care about those 3 things that it doesn't do. Now, if those 3 things are important to you, we'd want to make some changes. But if they're not, you're good. And they were good. So we're okay with that. We can brainstorm with you. We can provide those complimentary reviews. And we are also continually adding content to our website. We have a lot of tools, a lot of videos and articles that you can send clients to, and they can learn about, well, what is a Dynasty Trust? How does it work? How can I talk to my family about money? How can I conduct a family council? I don't know of any other law firm anywhere that helps their clients think through, oh, a family council. I should present this to my children in a rational manner. We coach and counsel and help our families, our clients do that. And we have some fun resources on our website to help with that. So we're at the end of our hour. It's been great to visit with you. Again, this is Durfee Law Group, also the Estate Planning Law Group and the Probate Law Group. It's been myself, Rick Durfee, Michael Koberlein, Sam Kelsall, and Kyle Hopson. We're excited to be here. We have a 1,000-year plan with our law firm. We have up and coming young people who are in the pipeline, some in law school, some who have recently graduated from law school that will join our firm. And so we plan to be here forever. Even if I'm personally not here, somebody will be here, and we're teaching and instructing our team on how to use all of these tools for the benefit of clients. So it's been a pleasure to work with you and visit with you today, and I did not see any questions pop up, so I'm going to assume there are none, and we will have this presentation posted on our website. It'll probably take us a few days, but if you want to come back and review it and see it again, it'll be up on our website. That's durfeelawgroup.com. And so that's it. Thanks all. Bye-bye.